particular.
Recording in progress.
Hello, and welcome to all of those of you who are joining us by Zoom. Thank you very much indeed. We still have quite a few people coming in through the waiting room, so if you would stay with us for a moment. Okay, we'll make a start. My name is Charlotte. I'm the convener of the Oxford Children's Rights Network, and it is my pleasure in many respects today. First of all, because this is the first hybrid, partially in-person seminar that we've been able to hold in nearly 2 years. So we're delighted to be back at the Bonavero Institute. And secondly, because to mark this auspicious occasion, not only do we have sandwiches, which we're sorry we can't share with our Zoom viewers, but we also have not one, but 3 speakers. I had the pleasure of meeting Robin about a week ago, where we went for a greasy fry-up breakfast as a truly English experience. And well, we just started talking about your work generally. It's, I think, very often the case that academics come to seminars and talk about the legal changes they would like to see and hope that there may be some policymakers or politicians out there who are listening. But the very exciting thing today is that we have 2 senior policymakers and politicians with us, President Adams of the Utah Senate and Representative Birkeland, also of Utah. And I believe that you will be talking about not what you wish to see happen, but actually a great example of collaboration in the spirit of Robin's work between academics and politicians, and the passage of a bill guided by children's rights. So I will pass over to Robin, who will be in charge of the slides. I don't know which order you want to speak.
I think I'm taking care of slides for everybody, okay? So I'll start there. I want to say what a privilege it is, and I especially want to, thank Christos for hosting us and the Bonavero Institute. It is an absolute privilege to have been at Oxford for these weeks. I only wish that President Adams and Representative Birkeland could have made the trip. So great thanks to you for this privilege. We are absolutely delighted to talk about really a live instance of the project that brought me to Oxford and to Queen Mary University, London, which is a Fulbright that I'm on. And if we could go to the slides, I'll start there. So I'm going to start with 1 sentence about a theory of civil rights. So I think civil rights in the United States are often like this. We think about one right just clashing and opposing another. And I don't believe they have to be that. In fact, I think most of those clashes are more perceived than real if we spend the time to try to resolve them in ways that take into account the interests of all persons. So the specific project that I'm here on the Fulbright about is what I call civil rights complementarity. It's the idea that civil rights are like puzzle pieces. They can be made to fit together, and all people can be fully authentically themselves in public and private, but it requires courage by state, in our case, state lawmakers. I'll show you why, a special role of the states in the US, as you well know, Julian, but it will be a special role for them to do this work of blending rights of people in deliberate ways. And we're going to talk about a live example of that. I thought it would be useful for just a moment, though, to tell you how it is that I happen to know these 2 folks. And so I want to go back to a prior example of civil rights complementarity in the United States. And that was something that President Adams, I had the privilege of assisting him, and he'll talk more about this in a moment, was something called the Utah Compromise. And just a quick one sentence about that. At the time that the Utah Compromise, which was a pair of bills, was enacted in the United States by the Utah legislature, Utah was the single most politically conservative state in America. And by some metrics, it was and still is the second most religious state in America. And they gave more rights to the full LGBT community in housing and hiring than that community had expressly in law at the time in New York, blue New York. So more rights to the full LGBT community than there was in New York at the time. And it was by trying to take seriously the concerns of people in the full community about what non-discrimination law would mean for them. This is actually a project that's very exciting right now. It's something that I think John Adnatiri is trying to lead a kind of version of this in this country and in Europe. So that was the idea of the Utah Compromise. In many instances, I think it's difficult for lawmakers to get to that idea of puzzle pieces because they don't necessarily know how to thread the needle between opposing camps. And that often means to do precisely what Representative Birkeland will describe in this context of transgender athletes. And that is to bring people together and try to hear what their questions and concerns are. So I think before we go, to the lawmakers, I want to do a little bit of table setting, just about the way in which we regulate things in the United States. And I want to start with this specific problem that's in front of us in the United States, which is the question of what to do with transgender athletes. Okay, that just consumed our headlines. So we have seen in the space of months, literally since March 2020 to present, 15 states in the United States ban transgender athletes from all sport, just absolute complete bans. Utah is alone, and you'll see Utah on this list at the top. There is a ban in the bill that we're talking about that was inserted at the very last moments of the legislature. And we can talk about that in greater detail, but Utah is alone in saying that if the ban is struck, and I believe it surely will be, by the way, I am not any part of a ban. I just want to be on record for that, okay? But it was inserted at the last moment. If the ban is struck, then the consensus negotiated brokered position comes up. And so what we will be talking about is the process for arriving at that consensus middle ground position. So Utah's alone in this group, but alone across the United States, and trying to bring community stakeholders together and ask, how can we find a path to inclusion instead of exclusion? So then a couple things that might help you. Julian may well know this, but some of you may not if you haven't spent a lot of time in the United States. We do not have a national sexual orientation, gender identity, non-discrimination law in the United States. 53% of Americans live in parts of the country that you see on this map in blue that do not have a SOGI non-discrimination law. That's in housing, hiring, and Utah also does not have a public accommodations. Okay, we'll come back to public accommodations in a moment. But that means that many people don't have the ability in our country to walk into a public space like this that could be excluded. So it's just mind-boggling across lots of the country. So that's one of our challenges. It means that we don't have answers on this question at the state level. Now, many of us in the United States, watched very closely this decision that came from the U.S. Supreme Court called Bostock. And it was a decision that the court, led by a conservative, written by a conservative justice, interpreted the 1972 Title VII Act, which is our Employment Non-Discrimination Act, to say that it extended to gender identity and sexual orientation. Now that got extended by President Biden when he came in office. That wasn't true under Trump. Biden comes in, very first thing that he does is sign an executive order that extended Bostock to all of the federal agencies. Now, I'm spending time on this because in the United States, lots of people are left out of Bostock because Title VII only covers employers that have 15 or more employees. So President Adams and I recently wrote a piece for the ABA Human Rights magazine that talks about how many people are still left out after Bostock, just from employment non-discrimination laws, which means that the way they identify or who they love can be used to fire them or not hire them or to disadvantage them. I mean, for many people, that is mind-boggling. And I think this means that even if you could blanket the country with some of these laws, the bottom falls out. The smallest employers still are not covered by federal law. And again, brings you back to the states. I'll show you a little bit more of that in a second. Now, at the federal level, see the T in the middle, trans, we have all bodies of law that will possibly, implicate anything that that an employer, a private agency, a school district, or whatever does. Not least of which is Title IX on the side. Utah receives Title IX funding, so we could talk about that in a moment. Title VII, we've just been talking about. Biden extended non-discrimination protections to housing in that executive order, so that's covered. Look at public accommodations on the top right. It will not be covered. And it will not be covered because the federal anti-discrimination law, the Civil Rights Law of 1965, Title II, only protects people on the basis of discrimination in things like race and national origin. It does not extend to sex. And because it does not extend to sex, it cannot be read to extend to sexual orientation or gender identity the same way Bostock did, which means that for public accommodations, for places like the library, the square, or colleges, many colleges in the United States, that is wholly the province of the states until there is either a Federal Fairness for All Act or the the Equality Act or something else that ends up canvassing that space, okay? So we'll come back to this idea of facilities, and it will be very much focal with the question of transgender athletes, because you have questions of locker rooms, facilities, bathrooms, all kinds of things. Hotel rooms if they're traveling. Disability law might be implicated, and of course the American the Affordable Care Act and the way in which we provide healthcare coverage to Americans. They're all provisions, but all of them just sort of circle around this and are not really dispositive. And then finally, the parent-child relationship, which is part of the 14th Amendment to the U.S. Constitution and the rights of due process of parents. So what does all that mean? We have kind of a sandwich in the United States. So you'll see this picture, Senator. I think I've drawn this for you many times, okay? But you've got federal law up here, you've got the states in the middle, and then you got home rule, local law at the bottom. I'll start at the bottom. One of the things that really pushed sexual orientation, gender identity, non-discrimination laws in the United States was local law. So municipalities led the way in saying that there would not be discrimination. That's a very delicate system with the states because the localities in most states can only regulate to the degree that the state allows them to regulate. So that leaves the state as a decision maker about what degree of local law that they would allow, okay? And it can't be in direct conflict. The state generally is where all the protection of general welfare rests. And I haven't shared this with this group, but I've written a piece about family law isolationism. Like, why is it that the United States stands outside of the Convention on the Rights of the Child? We alone stand outside now. It used to be us in Somalia and Sudan, but now it's just us. And we stand outside of the CRC because of state law. The states take very different approaches to the regulation of family and all general welfare, from crime to taxes to everything almost. Now, sometimes it's federalized, but I've just shown you that in the one key area, which is this idea of public spaces as it relates to this question of transgender athletes, federal law has at this moment nothing to offer. Okay. Now, it could be that Congress springs into action. We haven't seen Congress do that a lot in the last years, so I don't hold my breath that it's going to be Congress, which is the reason that I think we come back to the states in such a strong way. Okay, so that's a quick primer on U.S. law. And Senator, President Adams, I'm sorry to keep calling you Senator, but when we first met with the Utah Compromise, you were the Senate Majority Whip as opposed to the President of the Senate. But I want to just leave off here and let you pick up there.
Well, thank you, Robin, and it's really great to be with you. I hope you can everyone hear me okay? I'm going to go back a little bit because I want to explain a little bit of how I met Robin, and also because I think there's a parallel track as to what we did together versus what we're looking at with the transgender sports issue. My legislative experience was a little bit separated. I served in the House of Representatives in Utah in 2002 to 2006, and then left and then came back and into the state Senate in 2009. But when I was in the House of Representatives in Utah, we ran a bill. And as Robin indicated, Utah is a very conservative state, a very religious state. And I helped participate in a bill that defined marriage in Utah. And it defined marriage between one man and one woman. And we actually passed the legislation and took it a step further and took it to a vote of the people. When we to actually place it in our Constitution. So it was a constitutional amendment defining marriage between one man and one woman. We thought we had basically locked up that definition, and we put the issue behind us and moved on. As I mentioned, I came back into the Senate in 2009 and really hadn't thought any more of that piece of legislation. Utah has a very short legislative session, and in December, as Robin indicated, I was in Majority Whip in the Senate, but in December, a few days before our legislative session starts in January of 2013, a federal court judge, Robert Shelby, actually overturned that constitutional amendment. That caused a lot of anxiety. I had constituents that were frustrated that, with the vote of the people, I think the vote was in the close to the 70% range. A super majority of the residents of Utah wanted that definition to stay. They were upset that any court would override the rule of the people. And some of them wanted to actually, I got emails saying, let's secede from the nation. The LGBTQ plus community felt like they'd been vindicated, that their rights had been upheld. And they wanted to pass legislation that gave them protections in housing and employment. And we met as a leadership team, and because there were efforts to appeal that decision, in 2014, which was just 30 days after that ruling, in January, we just decided we weren't going to hear any bills dealing with religious liberty protections or with the expansion of the LGBTQ rights. That didn't sit well with the LGBTQ community. They got upset. They protested, blocked access to our committee hearings during our legislative session. 13 of them were thrown in jail. We ended our session that year, and then in June, we actually lost our appeal. And then later on in that fall, because there were no states that had given different rulings, the Supreme Court denied cert, which I'm not an attorney, but what I understand, they just decided not to hear our case. So in the fall of 2014, we started actually marrying gay individuals in Utah. It was a mess because we had a governor that said, I don't know if I could do that. And we had a speaker of the House said, why not? And we really didn't have any direction. And I would just say that a legislative body, I think I have a right to legislate. But beyond that right, I think I have an obligation. And this is an issue that we could kind of kick down, kick the ball down the road or defer. And so in 2015, we had lots of legislation that, again, we were looking at legislation that would have been punitive to the LGBTQ community, and the LGBTQ community wanted to extend their protections in housing and employment. We have one of the shortest legislative sessions in the country. It's actually 45 calendar days. There's only 33 working days. On the second day of that legislative process, on Tuesday, we had 4 members of the Church of Jesus Christ of Latter-day Saints of their Quorum of the 12 that actually said, we don't want this disjointed effort. We want to be able to find a common ground. And I was given the responsibility to try to find that common ground. I was fortunate enough to actually have Robin, Professor Wilson was in Utah, and I actually read in the paper about her visit and wanted to visit with her. And so I actually asked her for her help, and we started into the process. And it's really easy to say that you want to combine issues and you want to be able to find perhaps some type of common ground, some type of balance, some type of fairness for all. It's extremely difficult to do it in a statutory and a legal form, and to be able to, again, have that balance of effect. We went to work, and we did pass a piece of legislation that Robin talked about at the very final weeks of our session. A couple of things that it did, and again, it's really important that if we believe in equal rights, we believe in fairness, we believe in making sure that all people's rights are protected, and sometimes we forget that. And I learned through this process that when we protect the rights of others, many times we end up protecting our own rights. So let me talk a little bit about what we did. We actually gave a definition of and the definition we actually used for gender dysphoria is the American Psychological Association's definition, which actually requires some type of evaluation. We gave protections to both employers and employees. Because of that definition, and I'll get back to that in a minute, but we'll leave that slide up for a minute, Robin. Because of that definition, we gave some consistency to employers that they might be able to know and be able to handle and be able to make public accommodations and be able to do that in a reasonable fashion. And so we gave protections to employers that they could that they couldn't be that they would have the ability to decide what speech happened at work, but we also gave the protection to the employees that they would be able to speak freely about either religious issues or sexual orientation issues at work. The simple public accommodation was perhaps a lock on a bathroom door, but to be able to have that definition and to be able to do it in a non-confrontational setting. We protected, we had, as I mentioned before, we had a little bit of confusion as to who might marry. We actually gave definition to that. We indicated that every clerk in Utah had to perform gay marriages, which gave great protections to the LGBTQ community. But many of those clerks didn't sign up to do that. So we actually put a process together that allowed them to step off if they could find another willing person. And many people wondered how that would work. And some of you may have heard in the news, we had a lot of issues about a clerk by the name of Kim Davis, who denied those rights. And in Utah, that actually happened in the fall of 2015. Our bill was passed in the spring of 2015. And it was a big issue as to how Kim Davis might be able to handle her responsibility as a clerk. In Utah, we actually had 2 counties that had decided to step off. One was the county I live in, Davis, and the other was Weber County. Those clerks simply put together a list of everybody in the county that might be able to marry. So when an individual comes in to be married, they're treated with no discrimination. But anybody that comes in gets the list. Doesn't matter whether you're gay or straight or whether you're black or white or purple or pink, you get the same list. So no discriminatory act. And I asked the clerks how it's working, and they actually told me that it's working phenomenally well, because many of the people that come in to actually fill out the marriage certificate don't really know or haven't thought about who might marry them. So they actually look at it as a service. So again, trying to find that balance of protecting people's on both sides rights, and to be able to do it in a non-discriminatory fashion that allows people to be able to feel the self-dignity and the self-esteem of not being discriminated against. So what was the result of the legislation? You're seeing it on the screen in front of you. That picture is a great picture. I'm there next to the governor of Utah is holding up the bill. He's actually holding it up in front of himself so you can't see his face. I'm just to the left of him on the screen. Our current governor, who is the lieutenant governor, is sitting at the table. The Speaker of the House and President Senator there. You can see behind, though, Professor Wilson, I think next to on the far right there. But next in the audience, or I think is an unbelievable group. We have multiple members of the LGBTQ community. We have the Catholic Diocese was represented. Members of the Quorum of the 12, of the Church of Jesus Christ of Latter-day Saints are there. So you have this coming together of you saw the train wreck before. We were coming together, and there was going to be an explosion. Instead of that explosion of the trains, you actually had these groups coming together in what I would say is a balanced effect. The legislation is referred to sometimes as Utah Compromise. I'd rather call it fairness for all, because my deep-seated religious beliefs are not compromisable, nor I would think are those beliefs and those desires for protection in the LGBTQ community. And so how does that apply to what we're doing now? And I maybe just say that as Representative Birkeland, who stepped forward with great courage to be able to solve this transgender sports issue, as she did that, I looked at what she was doing and thought that I might reach out again to my good friend, Professor Wilson, to try to get some help. And when we look at this new issue, it has some of the same complexities as we had with gay marriage. And one of those is to be able to determine how we move forward. The data that I've actually seen shows that many of the men in Utah who want to transgender to be female, it's up and perhaps up above 90% of those who start into that transition process that actually melt and come back. And so we wanted to find a process that didn't require a chemical usage, because we were concerned, especially about adolescents, those minors that might want to try to participate in sports, that this may not be a final decision for them. And in doing so, we wanted to find a way that instead of using puberty blockers or other different chemicals, that we would actually use the definition that we put together in the Fairness for All. And that is the American Psychological Association's definition is gender dysphoria. And that's what we used as a basis for, and you see it on the screen there, for the beginnings of the piece of legislation. We then wanted something, and again, Professor Wilson talked about the bans. That sounded very familiar to the 2004 era as far as definition of marriage. And we've seen the court ruling, actually many of them either staying or trying to strike those down. I don't think that's a lasting event. And so the ban is probably not the way forward. So we wanted to find something that was balanced, and again, in a fairness for all approach. And Professor Wilson suggested the idea of a commission. And Representative Birkeland will talk more about it, but the things that I liked about the commission were a couple of things. One is, again, that it didn't require the use of chemicals or those type of things to determine whether somebody would play. But it also used a data-driven approach. And the data-driven approach has a couple of, again, great advantages. First of all, it's fair. And we like using data-driven approaches in Utah. But second of all, those on the commission, they want to be able to, if they're going to determine who plays and who doesn't play, we don't want that to be a political decision, an arbitrary decision, but we want that to be a decision that actually is driven by data. So with that, I'm going to turn this over to Representative Birkeland because she'll talk more about what we did. But I think we found, again, a way forward that not only is fair, but I think it'll be upheld by the courts. And again, it helps everyone to be able to be represented and to be able to do it in a very data-driven way. So Representative Birkeland, I'm going to give some time to you now.
Thank you, President Adams, and thank you, Professor Wilson, and everybody for this great opportunity. I do believe that common sense should be more readily used when making legislation across our state and nation. One thing that I think is important that we talk about right away is that I do have 3 daughters who participate in high school athletics. I officiate high school athletics on the football and basketball court, and I coach high school basketball. I have seen firsthand what happens when young women feel like there's an unfair advantage used against them in the competition world. Women primarily feel that they're not given the same respect still, even here in Utah, that the boys receive. And so they take very serious anytime that there is an unfair advantage given to, males versus, they and their friends. So I do coach, and we recently coached a basketball game and played a basketball game, and I had some transgender athletes on the team we were competing against. And we went into the locker room at halftime and we were winning. And it was very hard for the girls on this team to be happy. They felt frustrated. They felt just unsure of how they should feel. They should be happy. They should feel successful. But because there were transgender athletes and there was a lot of talk going around the fact that we were going to be playing transgender athletes, it left them feeling unsettled. And I think that is what ultimately has been our goal ever since I met Professor Wilson and have began working with President Adams, to create less of that divisiveness, to bring down the heat, so to speak, on a lot of this confusion and frustration of what is fair and what is right and what is common sense for high school athletics, particularly. And so what we also wanted to consider as well was for these athletes who are transgender, we want them to feel like they belong. But where is the best place for them to belong? How do we help them feel like they belong when we're frustrated on the women's side with their participation? And so we felt a process as President Adams spoke of, and he came to me with this idea of a commission and deciding based upon their abilities whether they had the biological advantages or whether they would be able to come in and participate in a way that was fair for all the athletes. If you want to go to the next slide, Robin. Now, it is hard in the United States of America when you talk about transgenderism and transgender athletics, when you have situations like Leah Thomas, who is breaking records. And that is the concern of so many people, is if we allow this to happen, records will be unattainable for the cisgender females. And women will lose places on the podium. They will lose their college scholarships. And that was definitely a concern that a lot of parents shared with me. I met with stakeholders from parents to coaches to the LGBTQ community to league organizers. And we met almost monthly for almost a year now to discuss how we could frame something that would create a path for youth to participate while still ultimately preserving the integrity of women's sports. And it took a lot of time, and there was a lot of tense discussions, and there's some points that we're probably just not going to agree on. And when I say that, I mean for the young women who are participating versus what some of the things that the LGBTQ community wanted. But where we could find common ground is where we needed to begin from. And with the commission, I think that is exactly where we started to see that common ground. Finally, it was no more let's change birth certificates, let's do hormone blockers, all these things that really no one was really buying. That number one, it was right for the kids to put them, as President Adams spoke of, to put them on these puberty blockers and hormone therapies. But was it even enough to create the fairness that we were seeking for? I think in looking at what we accomplished with the commission, right in our state, if you have an athlete who has a disability and they have a special need and they want to stay and play sports for a 5th season, they go before a commission that kind of talks about why they should be allowed this extra season when everybody else just gets the 4 years. And so it wasn't a totally new concept here in our state for athletics, but in this context, it was very new. And it basically says very similar model where if you are a transgender athlete and you want to participate on a team that differs from your identity at birth, then you need to come before this commission, and they would consider what your height is, what is the average speed, what is the average wingspan, like all these things that the student or the student's parents felt comfortable in sharing and wanted to share. It gives the commissioners, who are made up of doctors, therapists, coaches, athletic trainers, they would be considering all these different elements so that when that athlete is given the ability, given the eligibility status to go participate, the girls and their families know that this individual went through a process, and this process is what helps it make it fair. And that doesn't answer everybody's questions or concerns, but it's a starting point, and it's a starting point that we currently have not had in our state. And I want to reiterate again how important it is that people feel a sense of confidence and can then be more empathetic when they know that there has been a process in which someone went through before showing up, if it's to be believed that they have some sort of competitive advantage based on their biology at birth. And so from there, they come to the commission, they take all these things into consideration. I love how Professor Wilson has helped us define this baseline of what is appropriate on the bell curve for each of these student athletes based on their age, their sport, because obviously running track is very different than swimming. Soccer is very different from football. Everything is very different when you're talking about competition in athleticism. And so if we want to move to the next slide, Professor, the commission members are appointed by our governor, and he selects the athletic association appointee and an athletic trainer from a college level. And that's very important because I believe that athletic trainers understand the impact of injury far better than oftentimes, let's say, the sports physiologist. And that is who the Speaker of the House selects, as well as a board certified physician with experience, expertise in gender identity healthcare. And our good President Adams has a mental health professional, statistician, and we do have an ad hoc member that is selected by the Activity Association, the Utah Activity Association, and it's either a coach or an official from the sport that that student athlete wants to participate in. Because I can tell you, as a coach and as an official, I understand, again, what is a reasonable level of play, what you can expect between your freshman basketball players versus your varsity basketball players, and how many freshmen are currently playing on the varsity team if they are a cisgender girl versus how many transgender girls are playing as freshmen on the varsity team. And that kind of information is very helpful to us to ensure that, again, nobody is losing their place and being displaced, because displacement is huge in sports. If you want to think for just one moment, if I may, eligibility challenges date back far before we had any transgender athletes here in our state of Utah. Eligibility challenges happened because an athlete moved from one school district into another, and now they were playing for a different school district, and that upset people of, well, why is, you know, this kid playing now for this school, and now they have a better team, they have the linebacker they need or whatever. And so parents don't want their kids ever displaced or be given an unfair advantage, and not just for transgenderism, but in general, because so many of our young student athletes, they spend all their lives up until that point trying to perfect their athletic abilities, and displacement is huge for them. And so this commission really gives a full scope of what the needs are and what the reality will look like. And it gives us the data that President Adams spoke so much about, the statistical and scientific data that we need to make good decisions and help drive good policy going forward from there. And then if you want to go to the next slide, Robin. That basically wraps up what I have to provide to you all on the commission piece of this, and the importance that I feel like to just end with is just, we have some amazing young women here in our state, and they have a great amount of empathy and compassion, and they want all youth, whether they're transgender, cisgender, you know, whatever they're struggling with in life, they want to bring them in. What's so important is that we allow them to do that at the same time that we allow them to feel confident that we hear and see them as well. When we encourage our youth and we show them that we hear and see them, all of them, they come together so much better. And I'm grateful to be able to have worked with Professor Wilson and President Adams and all those who helped craft this commission, because I really think in the long run, it will provide the strength and give people the courage to see outside of themselves, which would not have happened if we had tried to go about this any other way.
Rep. Birkeland, that's terrific. Let me just make 2 quick points and then talk about a couple guardrails that are more drilled down on children. The top point for eligibility is a threshold one, but the commission has to consider the mental health advantages to the trans athlete of being able to play. You know, this is a group of folks who, you know, there's a lot that's going on in their lives. There's a lot of depression, there's suicide. A sense of belonging through sports has sustained lots of us in our lives, and that should be available to them on the same basis as other children. And so this is really sort of trying to take into account all the interests that are at stake. And I'll just go back and make one last point about guardrails, which is lots of the sort of, I think that whole slew of laws has been responding to one case, Leah Thomas, and she's, you know, an outlier, I think. Most of these kids, they, you know, they're pre-puberty or just after puberty, they're indistinguishable. You know, my predictive judgment is that in either direction, a natal female transitioning to be a male, which might have a safety concern for that child, or a natal male transitioning to be a female, which might have safety concerns in any direction. Both of those things have to be treated the same way in this structure. Otherwise, you have made a distinction on the basis of sex, which will receive heightened scrutiny in the United States, even of the commission structure itself. And so it was deliberately bidirectional, just as the Utah Compromise was. Representative Birkeland with stakeholders made a decision to leave religion, meaning religious schools, to the side. We can have a discussion with others here if you're interested in why. But that would have kicked, we believe, this entire structure into strict scrutiny because of a recent adoption case out of the U.S. Supreme Court called Fulton. And then finally, colleges have been figuring this out in theory, although they're all over the map in approaches, but the NCAA and others have already weighed in, so there didn't seem to be any percentage gain in trying to tell colleges or people competing at elite levels how to deal with that. This is about kids in primary and elementary school. And that's basically the mechanism. So I'm sure you will have lots of questions for these folks. Stop there.